Elon Musk stood before the Supreme Court of the United States, his tall frame commanding attention in the ornate chamber. The tech billionaire's unexpected appearance had already caused a stir among the assembled legal experts and journalists. Just moments earlier, Justice Amy Coney Barrett had directed a pointed question at Musk regarding his company's data privacy practices. "Mr. Musk, your company's collection of user data appears to contradict your public statements about privacy," writes, "How do you reconcile these contradictions under oath?" The question hung in the air, clearly designed to put Musk on the defensive in this unprecedented hearing on technology and constitutional privacy protections. What happened next left the entire courtroom in stunned silence. Instead of retreating or offering a defensive response, Musk reached into his briefcase and removed a single document that would transform not only this Supreme Court proceeding, but potentially the entire relationship between technology companies and government surveillance. The tech CEO looked directly at Justice Barrett and stated calmly, "With respect, Justice Barrett, before answering your question, I believe the court should be aware of information directly relevant to these proceedings." The entire room froze as Musk prepared to reveal something that would leave even the composed Justice Barrett momentarily speechless. Before we reveal what document Elon Musk presented that silenced the Supreme Court, please take a moment to like this video and subscribe to our channel for more exclusive coverage of the most dramatic confrontations between America's most powerful figures and institutions. To understand the magnitude of this extraordinary confrontation, we must first examine who these two formidable individuals are and why their clash carries such profound implications for American society. Justice Amy Coney Barrett, confirmed to the Supreme Court in 2020, has quickly established herself as one of the court's most intellectually rigorous members. A former Notre Dame law professor with a reputation for brilliant constitutional analysis, Barrett's judicial philosophy emphasizes textual interpretation and original meaning. Her questioning during oral arguments is known for its precision and depth, often cutting directly to the core weaknesses in attorneys' positions. As the court has increasingly confronted cases involving technology and privacy rights, Barrett has emerged as a key voice advocating for clear constitutional boundaries in the digital age. Elon Musk, by contrast, represents a different kind of American power, entrepreneurial rather than institutional. As the founder of Tesla, SpaceX, and numerous other ventures, Musk has transformed multiple industries while building a personal fortune that makes him one of the world's wealthiest individuals. Known for his unconventional approaches and willingness to challenge established systems, Musk has increasingly positioned himself as a champion of free speech and privacy rights. His acquisition of major social media platforms put him at the center of debates about digital rights, government surveillance, and the proper boundaries of online expression. The unprecedented hearing that brought these two powerful figures into direct confrontation concerned a case with far-reaching implications: United States versus Tech Freedom Coalition. At issue was whether government agencies could require technology companies to provide backdoor access to encrypted communications, ostensibly for national security purposes. Musk's companies had joined a coalition challenging these requirements as unconstitutional under the Fourth Amendment's protection against unreasonable searches. For Barrett, the case represented an opportunity to establish clear constitutional guidelines for privacy in the digital age, a legacy-defining issue for a justice likely to serve for decades. For Musk, the stakes were equally significant, but more immediate: the future viability of his business's promises to users regarding data privacy and security. The confrontation extended far beyond these two individuals. At its core was a fundamental question about American democracy in the digital age. Where should the line be drawn between national security interests and citizens' constitutional rights to privacy? The court's decision would affect hundreds of millions of Americans who use technology daily, potentially establishing precedents that would govern digital privacy for generations. As Musk prepared to respond to Barrett's challenging question, Observers from across the political spectrum recognized that this moment could potentially reshape the relationship between American citizens, technology companies, and government surveillance authorities. The tension had been building throughout the morning as the justices questioned attorneys from both sides. The government's lawyer had emphasized national security concerns, while the technology coalition's representatives stressed constitutional protections. When Musk was invited to address the court as the most prominent business leader in the coalition, expectations were high. Justice Barrett had listened intently to the arguments, occasionally taking notes. When her turn for questioning came, she focused immediately on what she perceived as contradictions in Musk's position. "Mr. Musk," she began, her tone measured but pointed. "Your public statements champion user privacy, yet your company's collecting enormous amounts of data. You oppose government access to encrypted communications while building AI systems that analyze user behavior. These positions seem inconsistent at best." Musk nodded respectfully, but showed no sign of intimidation. "Justice Barrett, I believe principal distinctions exist between consensual data collection with transparent terms and government-mandated backdoors." Barrett pressed further. "Your company's terms of service exceed 50 pages of legal language. Do you consider that meaningful consent when most users never read them?" The questioning continued in this vein, with Barrett methodically highlighting what she characterized as hypocrisies in Musk's privacy stance. Several other justices leaned forward, clearly interested in this line of inquiry. Justice Sotomayor nodded slightly at one of Barrett's particularly incisive points. Musk maintained his composure, but observers noted a calculating look in his eyes as Barrett continued her questioning. When she referenced a specific exchange between Musk's company and government agencies regarding user data, something shifted in Musk's demeanor. "Justice Barrett," he said carefully, "I'm curious about your knowledge of that particular interaction which was not included in the public record of this case." The courtroom stilled. Barrett paused momentarily, then responded, "The court has access to the complete record, including sealed materials." Musk nodded slowly. "Including materials that even the parties to this case haven't seen, Chief Justice." Roberts interjected, "Mr. Musk, please respond directly to Justice Barrett's questions." "With respect, Chief Justice," Musk replied, "I am attempting to address a critically relevant matter." Justice Barrett's question references communications that were under sealed national security orders. Yet, she describes details that go beyond what was provided to this court officially. The atmosphere in the chamber intensified. Justice Thomas exchanged a glance with Justice Alito while Justice Kagan straightened in her seat. Barrett maintained her composed expression. "Mr. Musk, this hearing concerns constitutional questions, not conspiracy theories about the court's information sources." It was then that Musk reached for his briefcase. "Justice Barrett, I had hoped to avoid this approach, but in the interest of complete transparency before this court, I must share something directly relevant to these proceedings." He removed a document in a transparent folder. "This is a transcript of a meeting that took place 3 months ago between representatives of my company and officials from the National Security Agency. This meeting was not included in any materials provided to the court officially." Barrett's expression remained neutral, but those seated near her noticed her hands tense slightly. "The reason this transcript is significant," Musk continued, "is that it reveals a systematic program of pressure applied to technology companies, including explicit threats of regulatory action if we failed to provide the backdoor access that is the subject of this very case." Justice Kavanaugh leaned forward. "Mr. Musk, how did you obtain this transcript if the meeting was classified? As the CEO, I instructed that all such meetings be recorded for our corporate records, regardless of government requests for secrecy. My responsibility is to my shareholders and users, not to agencies operating without constitutional authorization." The room fell completely silent. Court artists frantically sketched the scene as Barrett studied Musk with an unreadable expression. The Chief Justice appeared about to speak when Musk continued. "What makes this transcript particularly relevant today," he said, looking directly at Barrett, "is that it includes references to private communications between certain justices and intelligence agencies regarding this case, communications that occurred outside official channels." The silence in the courtroom deepened to something almost physical. Several journalists unconsciously leaned forward, sensing a historic moment unfolding. Barrett's face remained composed, but a slight flush had appeared high on her cheekbones. "Mr. Musk," she said, her voice perfectly controlled, "are you suggesting improper behavior by members of this court?" Musk held her gaze steadily. "Justice Barrett, I am stating directly that this transcript shows intelligence agencies claiming to have secured advanced assurances about how certain justices would rule on this matter. Whether those claims are true or merely attempts to pressure, my company is precisely why this document should be entered into the official record." Chief Justice Roberts tapped his gavel once. "This line of discussion is inappropriate. The court will take a 15-minute recess." As the justices rose to exit, the tension in the chamber was palpable. Barrett remained seated momentarily, her eyes still locked with Musk's. The tech billionaire stood his ground, the document still in hand, neither aggressive nor retreating. In that moment, everyone present understood that this was no longer simply a case about constitutional interpretation. It had become a direct confrontation between institutional power and an individual willing to challenge it publicly. As the justices filed out, the question hanging in the chamber was clear. What would happen when they returned? When the court reconvened 15 minutes later, the atmosphere had transformed from tension to electric anticipation. The justices returned with Chief Justice Roberts wearing an expression of grave seriousness. Justice Barrett, normally the picture of judicial composure, appeared slightly paler than before, though her demeanor remained professional. Roberts spoke first. "Before we continue, the court needs to address the document Mr. Musk has presented. Court security will collect it for review." Musk nodded but added, "Your Honor, I should mention that secure copies of this transcript have been provided to select members of Congress and major news organizations to be released if necessary. Transparency serves everyone's interests here." The strategic brilliance of this move was immediately apparent to everyone in the chamber. Musk had effectively prevented the document from simply disappearing into sealed court records. Several justices exchanged glances, recognizing the implications. After the document was provided to the court, Claire Barrett addressed Musk directly, her voice measured and deliberate. "Mr. Musk, you've made serious insinuations about improper communications between government agencies and this court. Such allegations demand substantiation beyond a single transcript that hasn't been authenticated." Musk nodded respectfully. "I understand the court's concern about authentication, Justice Barrett. That's why the document includes blockchain verification, timestamps, and cryptographic signatures from all participants, including 3 NSA officials whose identities can be confirmed. The technology my companies have developed makes document authentication absolute and indisputable." He paused, then continued with careful precision. "I would also direct the court's attention to page 7, paragraph 3, where NSA Deputy Director Warren specifically mentions conversations with 2 Supreme Court justices about creating a judicial framework for mandatory backdoor access. The date of these alleged conversations precedes the court's decision to grant certiorari in this case." The courtroom remained absolutely silent. Barrett studied Musk for a long moment before responding. "Mr. Musk, even if such conversations occurred, which I neither confirm nor deny, discussions about general legal frameworks are not improper. Justices regularly engage with legal questions through academic and professional channels. It was at this moment that Musk executed his most masterful move. Rather than directly challenging Barrett, he shifted to a tone of thoughtful consideration. "Justice Barrett, I have immense respect for your constitutional scholarship. In fact, I've studied your article on judicial independence, where you wrote that the appearance of impartiality is as crucial as impartiality itself. That principle resonated deeply with me and informed my decision today. The strategic citation of Barrett's own scholarship created a pivotal moment. Several observers noted a flicker of recognition in Barrett's expression. Musk continued, I believe we share a fundamental commitment to constitutional principles. My concern is not about individual justices, but about a system that allows intelligence, agencies to operate with such little oversight that they believe they can predict judicial outcomes in advance. This reframing was brilliantly executed. Rather than positioning himself against Barrett, Musk had aligned himself with her own expressed values while shifting focus to systemic issues rather than personal accusations. Barrett's response surprised many observers. Instead of defending institutional practices, she engaged directly with the constitutional question. Mr. Musk, leaving aside the specific document you've presented, there is a serious Fourth Amendment question about government, access to private communications. The founders could never have envisioned digital technology, but they understood the principle of securing private papers against unreasonable search. How do you suggest the court should apply those principles to encrypted communications? This pivot to substantive constitutional discussion represented a remarkable shift in the dynamics of the hearing. Barrett had effectively acknowledged the legitimacy of the core issue while sidestepping the specific allegations about judicial communications. Musk recognized the opening and responded thoughtfully. Justice Barrett, I believe the founders' intent is clear even if the technology has changed. James Madison described our papers and effects as the dearest property of every American. Today's papers and effects are digital, but the principle remains unchanged. Government backdoors make secure communications impossible, effectively eliminating the privacy the Fourth Amendment was designed to protect. For the next several minutes, Barrett and Musk engaged in a surprisingly substantive discussion of constitutional principles as applied to modern technology. Other justices occasionally joined with questions, but the central exchange remained between these two formidable intellects. Court observers would later describe this portion of the hearing as an extraordinary pivot from confrontation to constitutional dialogue. Barrett's willingness to engage with the substantive issues rather than becoming defensive about the document marked a turning point in the proceedings. As the exchange concluded, Musk made one final statement that many would later identify as the most powerful moment of the hearing. Justice Barrett, regardless of the court's ultimate decision, I believe we've demonstrated something important today. When powerful institutions, whether technology companies or government agencies, operate without transparency, constitutional rights inevitably suffer. My hope is that today's discussion advances a framework where both national security and individual rights receive their proper protection under our Constitution. Barrett nodded slightly, a gesture that conveyed acknowledgement without necessarily indicating agreement. The court appreciates your perspective, Mr. Musk. Your points will be given full consideration as we deliberate. As Musk returned to his seat, the atmosphere in the courtroom had transformed from confrontational tension to thoughtful seriousness. What had begun as a potential scandal had evolved into a substantive constitutional dialogue that cut to the heart of privacy rights in the digital age. The hearing concluded shortly thereafter, but everyone present understood that something remarkable had transpired. A genuine engagement with fundamental constitutional principles had emerged from what could have devolved into mere accusation and denial. The repercussions of the Musk-Barrett exchange reverberated far beyond the marble halls of the Supreme Court. As attendees filed out of the chamber, journalists rushed to file their stories, recognizing they had witnessed a pivotal moment in the ongoing tension between technology, privacy, and government power. Within hours, the hearing dominated news coverage and social media discussion. The hashtag #MuskVsBarrett began trending nationwide, though political observers noted something unusual about the online conversation. Rather than devolving into partisan attacks, much of the discussion focused substantively on the constitutional questions raised during the exchange. Legal blogs and constitutional scholars provided detailed analyses of the confrontation and its implications. Harvard law professor Lawrence Tribe wrote that regardless of one's views on digital privacy, the Musk-Barrett exchange represents a rare moment where fundamental constitutional questions received public attention typically reserved for political scandals. The document Musk had presented became the subject of intense speculation, though its full contents remained confidential. 2 days after the hearing, the Director of National Intelligence issued a carefully worded statement acknowledging that routine briefings occur between intelligence agencies and various government branches, but denying any improper influence on judicial proceedings. Inside the Supreme Court, sources reported that the regular Conference of Justices included an unusually lengthy discussion about procedural reforms. 1 week after the hearing, Chief Justice Roberts announced new guidelines requiring justices to disclose any substantive communications with executive branch agencies regarding pending cases, a move widely interpreted as a direct response to the issues Musk had raised. For Justice Barrett, the confrontation appeared to catalyze a significant jurisprudent development. When the court's opinion in United States V's Tech Freedom Coalition was finally issued 4 months later, Barrett wrote a concurring opinion that surprised many observers. While joining the majority in certain aspects, she wrote separately to emphasize that the Fourth Amendment's protections must evolve to address technological change while remaining faithful to the founders' core concern with government intrusion into private domains. Legal scholars immediately noted that Barrett's opinion represented a subtle but significant evolution in her approach to digital privacy questions. Professor Orrin Kerr of Berkeley Law observed that Justice Barrett has developed a more nuanced position that balances national security concerns with robust Fourth Amendment protections, a framework that may shape privacy jurisprudence for decades. For Musk, the aftermath brought both benefits and challenges. His public image was transformed, with many viewing him not merely as a successful entrepreneur, but as a principled defender of constitutional rights. His company saw significant increases in users citing privacy concerns as their reason for choosing his platforms over competitors. However, Musk also faced intensified regulatory scrutiny across his various businesses. 3 separate congressional committees initiated investigations into his company's practices, with particular focus on data collection policies. Industry observers noted the irony that Musk's defense of privacy rights had led to increased government attention to his own privacy practices. Perhaps the most significant outcome was institutional. 2 months after the hearing, a bipartisan group of senators introduced the Digital Rights and National Security Framework Act, legislation designed to establish clear boundaries for government access to digital communications. The bill's sponsors explicitly cited the Musk-Barrett exchange as highlighting the need for congressional action rather than leaving these fundamental questions to judicial interpretation alone. The relationship between technology companies and intelligence agencies also evolved in observable ways. Several major firms announced enhanced transparency measures, including regular reports detailing government requests for user data. The director of the Electronic Frontier Foundation noted that companies are clearly responding to what we might call the Musk effect, recognizing that users increasingly demand transparency about government access to their data. Law schools reported increased student interest in courses examining the intersection of constitutional law and technology. The dean of Stanford Law School observed that the Musk-Barrett exchange has become required viewing in our constitutional law seminars, illustrating how traditional doctrines must adapt to technological realities. For ordinary Americans, the confrontation brought abstract constitutional questions into everyday conversation. Polling conducted 6 months after the hearing showed that 72% of Americans expressed concern about government access to their private communications, with 64% supporting stronger legal protections regardless of their political affiliation. When the Supreme Court finally issued its ruling in the case, the outcome reflected the complex questions raised during the Musk-Barrett exchange. In a nuanced 6-3 decision, the court rejected blanket government authority to require backdoor access while acknowledging limited circumstances where, with appropriate judicial oversight, such access might be constitutional. Justice Barrett's concurrence became the most widely discussed aspect of the ruling. Her framework, which emphasized both textual fidelity to the Fourth Amendment and practical recognition of modern technology's role in private life, drew praise from across the ideological spectrum. A prominent conservative legal scholar noted that Barrett has demonstrated how originalism can address modern questions without compromising constitutional principles, while a liberal commentator observed that Barrett's approach creates meaningful privacy protections while acknowledging legitimate security concerns. Perhaps most tellingly, when Musk was asked about the ruling during a technology conference, he responded with unexpected nuance. While I would have preferred stronger privacy protections, Justice Barrett's framework represents a thoughtful approach to balancing competing values. The Constitution requires exactly this kind of careful consideration, rather than absolutist positions. This measured response reflected how the Musk-Barrett confrontation had evolved from potential scandal to substantive dialogue. What began as a moment of high drama had transformed into a genuine constitutional conversation with lasting implications for American democracy in the digital age. 1 year after the hearing, Harvard Law School hosted a symposium titled Constitutional Rights in the Digital Age, featuring both Justice Barrett and Elon Musk as keynote speakers. Though they appeared on different days, both referenced their Supreme Court exchange as a moment that had deepened their thinking about the proper relationship between technology and constitutional protections. The confrontation ultimately transcended the individuals involved to raise fundamental questions about how America's founding documents should govern an era the framers could never have imagined. As technology continues to advance and new privacy challenges emerge, the principles articulated during that extraordinary Supreme Court session will likely shape the ongoing evolution of constitutional interpretation. As Musk observed in his Harvard address, the Constitution endures precisely because it establishes principles rather than specific applications. Our task, whether as justices, entrepreneurs, or citizens, is to apply those principles faithfully as technology transforms the world the founders could only begin to imagine. If you found this analysis enlightening, please like this video and subscribe to our channel for more in-depth coverage of the powerful confrontations shaping America's legal and technological landscape. Hit the notification bell to be alerted when we release our upcoming special report, Digital Rights in the Balance: How the Musk-Barrett Exchange is Reshaping Constitutional Interpretation.